And welcome back, everybody. This is the Law and Crime Network. Taking a quick break from the Mark Sievers case out of Florida to talk about another case out of Florida. Just wrapping up this week, the Henry Segura case. We talked last hour to Nathan Prince, the defense attorney. This hour, I have the pleasure of welcoming both John Fuchs, the lead prosecution attorney, and Sarah Dugan, who was there in the trenches as well. Thank you both for joining me. I appreciate it.
You're welcome. Thank you for having us.
So, congratulations. First of all, this was some battle. This is some case, and this is the second round. So let me ask you this. When the jury hung up 2 years ago and the break was in favor of acquittal, what was the thought process before bringing this case back to trial?
We had a lot of work to do. So we went back and we reevaluated how we presented the case. We also went back and found and made a determination about whether or not further evaluation of DNA and other scientific stuff could be done in order to possibly present the case a little bit better next time. We obviously changed some strategy on multiple different aspects of it in order to try to have a cleaner presentation this time.
So let me ask it, and whomever you think is best to answer, just jump in. Were you surprised when defense went with a 6-member jury?
It's kind of hard to say because Mr. Prince had been talking about that for a while. So he broached the subject, quite frankly, probably almost a year before we went to trial. So I can't really tell you whether I was surprised or not at that point, because by the time we got to trial, I knew it was coming.
Yeah, what was the gut feeling like? Okay, this may be good. I mean, there had to be, because it's unusual, so there had to be some sort of visceral reaction to that.
The state opposed it. We opposed it for multiple reasons. There's a lot of studies out there that say some of them are better for 12 persons, some say it's better for 6 persons. But the biggest factor, of course, is that we were trying to preserve it for appellate issues and eliminate any appellate issues. So as a result, we actually opposed the 6-person just to try and make sure we didn't have an appellate issue there.
Well, it certainly worked out for you. So let me talk about the pachyderm in the courtroom here, the DNA. And a lot of folks, and I will be brutally honest, I'm included, didn't think you had what you needed to overcome some of those issues that I feel created reasonable doubt. How did you approach these DNA issues that seemed to favor the defense?
Explain them. Just be honest with the jury. Tell them what we had, what we didn't have. We obviously went out and spoke with Dr. McElfresh, who is literally the father of the DNA forensics, about what he can tell us about these findings in order to just let them know what was there and what wasn't there and why there wouldn't be something. DNA wasn't there as far as could point to who actually committed the murders, but there also wasn't a DNA saying anybody was in the house, period, other than Brandy, and obviously there was.
So let me ask you, Sarah, you know, the shovel, the spade, allegedly the calling card of the cartel. I didn't really hear any other theory as to what it was. So did you just figure, the jury will just kind of gloss over that, it won't mean much to them?
Well, I think that it's a house full of children. The shovel was very small in size. We thought, it's just probably something that a child could have brought in at some point. It was obviously there before the beating of Brandy Peters occurred. Her blood was spattered on it. There was also dirt on the spade portion of the shovel, so it wasn't something that the cartel members had recently purchased and placed there as some type of sign that they did this crime. So we kind of thought that theory didn't really make sense.
When you first heard this alternative suspect theory of the whole cartel issue, and I'm assuming you explored whether or not Brandy Peters had some connection to the drug trade, yes?
Correct. Yeah, this was very extensively investigated. We had cooperation from DEA. We had Tallahassee Police Department obviously investigating it. We had cooperation with the Federal Bureau of Investigations, especially in tracking down Mr. Avila and tracking down the issues that all surrounded this, including where Mr. Avila would have come from, and that was Mr. Santos. So, we went down and extensively investigated, talked to people she knew, look at her phone records, look at all of her housing records, and everything just indicated, one, she was not trafficking in narcotics. But further, you also look at where Avila came from as far as the name goes, and that was James Carlos Santos. And
so You know, Mr. Santos, speaking of that character, he did not testify in the first trial. Very different result, clearly. Do you think he had a lot to do with the jury disbelieving the cartel theory? And if so, why or why not? So my question was, Santos did not testify in round one. He had many issues, a lot of issues. Do you think his testimony in the second case actually hurt the cartel theory?
Absolutely. I was just saying before that Mr. Fuchs did an excellent job.
And welcome back, folks. This is Law and Crime. I'm Michael Bryant, and we have with us here John Fuchs and Sarah Dugan. They are the co-attorneys for the prosecution in the Florida case against Mr. Henry Segura, achieving a guilty verdict as to 4 victims. Brandy Peters, her 3 kids, one of them the child of Henry Segura. That was earlier this week, and then just yesterday, a life without the possibility of parole sentence against the defendant. So let me ask you, we were talking about Mr. Santos, because to me he was critical, probably as critical when he didn't testify in the first case as he was when he did in this case. Did you know he was going to testify? Was it a crapshoot? How did that all unfold?
It was definitely a crapshoot, because sometimes he comes in and says he's going to testify. Other times he comes in and says he's going to take the fifth and not going to testify. We did a couple of hearings in the week leading up to the trial, in which he indicated he would in fact testify. We were ready to go if he did, and quite frankly, we wanted him to, because it showed what the source of this Mexican cartel hit was, and that he just is not a reliable source.
And so is the bottom jury just figures this guy wants to be the star, and he's going to just tell the story, even if it makes him out to be the guy who set up the hit?
Yeah, I mean, I think that, you know, the cross-examination brought out the fact that he's just clinically diagnosed with having just grandiose ideas about who he is and what he does, and it's all delusional. It
was strange that in the first trial he didn't testify because he was afraid of repercussions for naming people. In the second trial, he makes it sound like if I don't testify and kind of step back and say I did this, that would lead to repercussions as well. Think that might have been an inconsistent problem for this jury?
Everything he says has been inconsistent across the board. Further, the fact he's talking about 7 people were in the house that just didn't agree with the forensic science that came out of the house with 1 shoe print and 1 void pattern. So, quite frankly, everything he's ever said is inconsistent.
Yeah, I mean, you have to acknowledge that the nature of the crime is so outrageous, so gruesome, and so violent that it's hard at first to put one person to that mix. I mean, even logistically, how do they handle the kids if Brandy is the first victim? Do you understand what I'm saying? And what did you think was the way to best describe to the jury that one man could do this?
Well, the biggest factor, of course, is unfortunately we see entirely too many domestic situations. And when we're talking about children that are 3 to 6 years old, they don't join in the fight. They run and hide. In this situation, everybody agrees they would have done exactly that. They would have gone into the bathroom. They would have hidden there. We think that he killed Tamaya right off the bat as he came in and started these gruesome events. At that point, he really only has to control Brandy. And he had a very difficult time controlling Brandy, which also indicates there's not multiple people here. Had there been more than one person, she can't escape the master bathroom. She can't escape the master bedroom. She can't run down the hallway out the front door if there's multiple people there to stop her, which leads credence to the fact that it is, in fact, one person. That's the only way she's able to escape from that one person. Meanwhile, the other 2 remaining children are just in hiding, hoping that the boogeyman will go away. And unfortunately, he didn't.
Yeah, and clearly they all knew him, so access to the home was not that surprising and not that big a deal. What about the motive? Let's talk about the motive, because that's been criticized by a lot of folks, and I've been skeptical that would somebody really do all of this for 20 grand burden in child support? How did you wrap your head around that and figure it's enough?
Well, this case also wasn't just about child support. You know, Brandy Peters was taunting him, saying, you're stupid for, ever thinking that you're the father of this child. And then at the same time, threatening to put him in jail for not paying child support for this child she's saying isn't his. So I think he felt very wronged by her and deceived by her. And I think it was almost like a respect thing, too, for him.
Yeah, it seems the jury must have decided, okay, if you pile on what the failure to pay that child in support might also mean: jail, loss of his license to work, inability to go take this foreign job where he's going to make some money. They certainly had to have taken that initial concern and expanded it to the logical extreme that you guys were selling, and they bought it. So good for you on that front, because I think going in, it seemed to be kind of a little concern for most people who were following this trial, especially considering the outcome of the first trial, which was, of course, without Mr. Santos. And I again think he was so important to get him up there in this second trial. What about the witness that the judge would not allow? The witness that was going to talk about how Mr. Segura learned the details of the crimes. Didn't get to testify. You didn't want that to happen.
I don't know which witness you're talking about.
The hairdresser? I'll call her the hairdresser.
The hairdresser? She's a girlfriend of his. She's going to say whatever she wants. I mean, even in jail, he's got multiple girlfriends. It just doesn't comport with what the family wasn't told how the children died. Law enforcement, they don't reveal certain things like that about the crimes because they want to be able to use that for interrogation of potential suspects. The autopsy wasn't even done yet, so they wouldn't know how the children died because the autopsy wasn't done. She says that she told him that, but again, that's Henry Segura saying that along with one of his girlfriends. You take it for what it's worth.
Yeah. I think
so
also had.
I'm sorry. Go ahead.
No, just that there was a prior inconsistent statement by her about that in her interview, and then also the defendant himself told police something different than what he said on the stand. So that was all.
I would expect, obviously, an appeal is going to be filed here, and that may be one of the grounds. So as you work your way through this trial, now the second time, you must have some sense of what the appellate issues are, how strong they might be. How do you prepare for that, if at all? And is that just handed off to somebody else to deal with the appeal?
That's the Attorney General's responsibility. They handle the appeals in the state of Florida.
Okay,
obviously, they call us up and talk to us, and we'll consult with them. But they handle the appeals.
Any general concerns in this case? You think you got a solid verdict?
I think there's some issues that they'll be able to write the appeal on, but I think ultimately they're really non-issues essentially. So I'm pretty confident that on appeal it will be upheld. Okay.
One last question on the penalty phase. Did not get the death penalty. Thoughts on that?
I understand jurors. They're debating on whether to take a life or not. That's a very, very heavy burden on anybody. There's obviously issues with the proof that you discussed. To ultimately decide somebody has got a death penalty, you've got to be 100% sure, even beyond a reasonable doubt. In addition to that, you've got his lack of criminal history, and it's just a heavy burden. They debated it. They obviously debated and thought about it for a long time, and we respect their decision.
Okay, guys, I appreciate your time and effort. Everybody here at the network and our audience appreciates watching you work. Obviously, you did a very good job. So thank you again, Sarah Dugan and John Fuchs, the team that got Henry Segura to the guilty verdict and ultimately a life sentence without the possibility of parole. Thank you, guys. Have a great holiday. I appreciate it.
Thank you. Happy holidays.
Okay, take care.